Yes, Mr. Southey.
My Lords, when we broke, I was making submissions about Putnam. Just one thing, I need to move on, but one thing that I would just emphasise about Putnam is the language that Lord Justice Bingham, as he then was, used towards the end of page 759 in that passage where he talks about collective integrity. And he talks about the high regard in which juries are held depending on their collective integrity and their individual integrity. And that's important in one sense because it demonstrates how, in our submission, judges actually, although obviously judges need to avoid discharging unnecessarily because it's a waste of resources, etc. At the same time, judges should not be reluctant if the circumstances arise to discharge the jury, because it's by doing that that the regard of the jury is, in one sense, preserved. It has one other factor, that it has one other result, which in our submission is demonstrated by the facts of this case, and explains why discharging the jury is not that uncommon, we would submit, and that's that discharging the jury in the right circumstances prevents people having to then exercise appeal rights, essentially potentially being held on appeal, in custody rather, until the appeal's hurled. It ensures effectively that someone's fair trial rights are vindicated as soon as possible. I'm going to move on fairly quickly because of time, but there are a couple of things I just want to make, a couple of points I want to make about the suggestion, which seems to be at the heart of the prosecution case, essentially, which is that all of this could be dealt with by jury directions. And the first point I want to make is it links back to the question, or the point I think my Lord Reid put to me just before lunch. Jury directions can be, I was about to say are, but I don't think it won't always be the case, and that's why I changed my language. Jury directions can be important ways of keeping a trial on track. The fundamental problem, though, in this case, there are two fundamental problems that explain why jury directions, even if they had been in stronger terms than the ones in this case, would not have been enough. And the two fundamental problems are this. Firstly, it goes back to a point I made this morning. One of the jurors had already been willing to offer bribes. He was willing to break the law. Directions assume that the juror will comply with what they're being told. But if a juror is willing to demonstrate that they are willing to break their oath, willing to act unlawfully, directions cannot solve that in our submission. The second problem with a direction is that implicit in Putnam, and what is said in Putnam about the potential for late reporting, for example, demonstrating that a juror had failed to comply with their oath and was going to be unable to avoid being biased. Implicit in Putnam is the need to know how far the poison has spread, to use the language of Putnam, before giving a direction, because directions will only work if the poison hasn't spread too far or hasn't become too deeply embedded in individuals' thought-making process. Here, because of the limited information about what had actually occurred, in our submission, there was no way of knowing whether the directions were sufficient. And that's one of the reasons why questioning the jury can be important. We would say, and I'll come back to this in reply if necessary, but it's probably clear from our case. In any event, all that was said in this case, of course, was that the jury were reminded of their oath. Smith, I won't take you to it, but it's 7671, House of Lords at para 24, makes it clear that directions need to be apposite, clear and emphatic. They were not in this case. And there's no reason why the jury couldn't have been expressly addressed effectively about bribes and how they should ignore the bribery attempt. Because, of course, on the evidence given, or the account given by the forewoman, not technically evidence, but on the account given by the forewoman, everyone was aware that there'd been this approach. Everyone was aware that one of their number had been placing a bribe. But as I say, fundamentally in our submission, this was a case, and there have to be those cases where it had just gone too far. The Crown has raised the issue of the proviso. In our submission, the proviso is inappropriate in this context, and we've certainly, neither side has been able to identify, as far as I'm aware, any case where the proviso has been applied in circumstances where an appellate court has reached the conclusion that bribery or similar problems have occurred. The reason for that in our submission is this. Under the Charter, as you've seen, there is a constitutional right to be tried by an independent tribunal. The Jury Act, unsurprisingly given what is common practice in many countries around the world, provides that that trial must be by a jury. No one has, in this case, none of the defendants in this case, have waived their right to trial by jury. Waiver, we make reference to it. Again, I won't take you to it because it's probably trite. Miller and Dixon, Lord Bingham, waiver has to be voluntary, informed and unequivocal. The reference to that, if you want it, is page 7008, paragraph 31. So no one has waived their rights. If the proviso were to be applied by this court in relation to the jury issues, it would be this court then effectively deciding on guilt, having not heard any evidence, having not been able to assess the witnesses, having inevitably, and this is no criticism of any party, having inevitably limited information. And that's, as I say, not consistent with the rights that I've just described, the clear rights as a matter of Jamaican law to trial by an independent jury. That's why in our submission the Court of Appeal was right in Brown to say it doesn't matter what, effectively paraphrasing, what the strength of the evidence was, because ultimately there was a right to trial by an impartial tribunal. We submitted yesterday a judgment in the Supplementary Authorities bundle by Chandon, which is a judgment of the Court of Appeal of Guyana. Page 16 and 17 of that supplementary bundle, which is page 226 and 227 of the report, which is last two lines of page 16 and the first 5 of the next page, adopts the approach I've just described, which is saying you can't apply the proviso because there was a constitutional right to trial by 11 jurors. Actually, not a constitutional right, but a right as a matter of law to trial by 11 jurors. One of the reasons for that, I've given a number of sort of fairly fundamental reasons. That's obviously also consistent with the approach in Putnam, as I took you to. One specific reason for that is that, as this court will be aware, and as is clear, for example, in the judgment in Bonnet-Taylor, which is in the authorities at 6289, paragraph 20, the normal approach that is often adopted in things like fresh evidence cases is to consider the impact, essentially, of whatever occurred or didn't occur on the juries, on the jury. Well, in a fresh evidence case, one can do it, and what that does is respect the role the jury plays. It looks at what the jury must have concluded, which is that the individual who's appealing his guilt was guilty, and then considers what impact fresh material might have. Here, one doesn't have that starting block, and that's why applying the proviso essentially would be this court determining for itself guilt, because it doesn't have a reliable starting point. So in my submission, it's not surprising, simply that there doesn't appear to be any case where the proviso has been applied in a case where there's a problem with a jury. Well, a problem in the sense of certainly a lack of independence. I mean, there may be other problems, but... My Lord
I'm sorry. I'm not meaning to look pained.
Yes.
I'm trying to remember an authority. We had a case in this court. We had a case in the Supreme Court a few years ago where the judgment was given by Lord Wilson to do with unfairness by a trial judge.
Yes.
And the court, in the judgment, Lord Wilson said words to the effect that a judgment which is the result of an unfair procedure is a thing writ in water from which nothing can follow. And you might rely on that idea in relation to a verdict by a jury which one could not be confident was an unprejudiced jury.
Well, my Lord, yes, but in one sense I would put it even higher because of the role the jury plays in our system, because of the importance of the integrity of the jury being preserved, and because there is, in particular, a constitutional right to an impartial and independent tribunal. I mean, they are really important rights within the system of criminal justice. To state the obvious, to state the and you are potentially denying that. I'm helpfully. It's extraordinary. How quick juniors are these days. Seraphine, I'm told, is the judgment.
Right.
Para
Yes.
49.
Yes.
Turning then to the issue of time of jury, I'm not going to spend very much time on it, partly because obviously in one sense the jury shouldn't have been retiring at all on our case, but it does in one sense add to the overall concerns about this case, because it's quite clear, and the Court of Appeal recognised this essentially, that one of the reasons why the judge was keen to get the jury out, so as to speak, is because the trial couldn't continue without that juror, and so you had this situation where there was a potential need to take action against a juror who and so a quick verdict was being sought. Now, the Jamaican bench book clearly recognises the potential pressures that can be put on a jury, and we would submit that one of the problems, if you have a jury that already has poison within it, to use that language again, one of the problems with pressure, the problems of pressurising the jury become even more intense, and the reason for that simply is that if a jury is going to be potentially be influenced by unconscious bias, that risk increases if people are effectively pressurised to take a quick decision, not think through the evidence. You go to your prejudices, unfortunately. Some people tend to go to their prejudices if they're under pressure. That's the simple point I'm making. And there is clearly a recognition now that sending a jury out late puts pressure on them, and it particularly puts pressure on them in a situation such as Jamaica, where there is no opportunity essentially for the jury to be discharged. They know they're going to be kept together. They're not going to be able to go home until they reach a verdict. That's recognised. The passage I've been referring to in the bench book is at page 6801, paragraph 5 of the bench book, which recognises what it describes as a 3 p.m. benchmark, but recognises flexibility both ways. And so in complex cases, remember this is apparently one of the longest criminal trials in Jamaican history, in complex cases it may be necessary to complete the summation earlier than 3 p.m. to avoid pressure.
I'm sorry, could you give me that page number?
Sorry, 6801, and it's paragraph 5.
601. 8601.
No, 6801.
Oh, I beg your
Sorry,
pardon.
no, that was probably me.
No, elevator one.
And of course, in this case, you had the added complication that when the jury was sent out, they came back essentially at 5:35, were asked if they'd reached a unanimous verdict and said they hadn't. The reference to this is 5176. The prosecutor then pointed out that they'd not been out for 2 hours, which is the point at which a majority verdict would be reached. There's no direction essentially saying you may want to, you need to try and reach a unanimous verdict. That's inconsistent with another passage of the bench book that is at 8362.
And can I ask, in Jamaica, if they go out and they haven't returned a verdict by a reasonable time in the evening, is the practice to send the jurors home, or are they sequestered in a hotel?
They cannot be sent home, so they have to be sequestered, basically.
Yes, and so are they kept in a hotel under court supervision?
That would be my understanding, what we like. But obviously, the bench book is premised on the idea that it's ideal that that doesn't happen, really.
Yeah, but even sending, I mean, I know from my own experience, even sending out the jury earlier in the day, that you can still have them out overnight.
Yes, absolutely, obviously, and that's not uncommon.
In fact, sometimes it takes a number of days before they return a verdict.
But does sequestering happen in Jamaica? Because I noticed there was another case where the hearing went on until 1:30 in the morning, where you would have thought they'd all be in a hotel by then.
No, in practice, sorry, I should have been clear. In practice, it doesn't, because there's just no real provision for it. So the jury just stay late.
But there is a rule that they can't be separated once.
The Jury Act is clear on that. They can't be separated.
So deliberations can go on for days and they'll just be kept without being sequestered in a hotel?
In principle, I suspect in reality that doesn't happen because of the natural I mean, we haven't put this in because it didn't seem relevant, but there is old English case law about juries being reaching verdicts at 3 in the morning.
Yeah.
Yes, well, the leading case on coercion of a jury is one where the judge refused to let them have anything to eat or drink until they returned a verdict.
Have you got the reference to the Jury Act indicating that the jury cannot be, once they've started deliberation, can't be
I'll
sent home?
I have got that in my notes, sorry.
Well, don't bother now, but if it's not immediately, if somebody could just...
It's section 47 of the Jury Act, which is electronic bundle 6805.
Thank you.
I think actually, just sort of as an aside, it was George Davis. If you remember, the George Davis is innocent. He was an early hours of the morning verdict. If that's a sort of historic.
That's not that long ago.
Yeah.
But they can be sent home, as I understand it, before they start to deliberate.
Yes.
So a judge who finishes something up, say at tea time, could just say to the jury,
Well, that's why
come back tomorrow and you'll deliberate.
Well, that's why the bench book makes express reference to when you finish your summation, because that's really what determines it. So what I suspect happens, my experience of English courts,
save the last direction about unanimity and electing a foreman until first thing the next morning.
Exactly, and that's not uncommon even in England, where you're getting late.
Regular.
You have 2 minutes worth of summing up.
Yeah.
But paragraph 5 in the bench book rather suggests that the solution is not, if you finish your summing up late, to send them home, but not to finish your summing up late.
Well, I think that it's because of the technical issue of when do their deliberations start. But all you need to do is have like one line of your summing up, and that
just save the last sentence of your summing up.
Yeah.
Okay.
47.3 at page 6805 does imply, well, it does say that the judge can give directions as regards accommodation.
Yes, but I understand in practice, and obviously I don't have direct experience, but those who do tell me this, that in practice that's not applied.
Thank you.
Final issue, and as I said, there are obvious issues in relation to the time in this case, particularly given the complexity of the case. In terms of what you should do if you're with me and have concluded that the conviction should be quashed and the proviso shouldn't be applied, we would invite the court not to remit. This has obviously been outstanding. The appellants have all been in custody since the 30th of September 2011. That delay is likely to have had an impact on evidence. There are, as the court will be aware, because of the application for expedition, there are issues with the health of one of the appellants. There are also obviously constitutional issues, but they've been denied. We would submit constitutional issues, even if it's the jury point. They had a constitutional right to a fair trial. If we're wrong about that, though, we would invite you to consider remitting to the Court of Appeal so that the Court of Appeal can consider the issue of retrial. That, I think, concludes all I have to say. I think Mr. Buchanan has some additional submissions.
Yes.
Yes, Mr. Buchanan.
If it pleases the court, Lords and ladies, I just wish to make a couple points, but to start with questions, the clarifications to questions. The first one being raised by Lord Lloyd Jones, and this would have been in relation to in relation to the chamber hearing. Now, in the Jamaican context, the right of the accused to be present at all stages of the proceedings. The concept of the chamber hearing, respectfully, would be that the courtroom would become the chamber. Yeah. So the gallery would be cleared, and certainly the attorneys, the representatives, and then you would have the accused there.
The bench book says that.
That's correct. But my lord, in that situation, because it was a situation within the transcript which reflects that it was actually a conversation between one of the appellants and the son of the jury. She didn't actually see or confronted the appellant. And so she was concerned, so she only heard information, and the inquiry didn't go as far as to find out the truth of that inquiry. And so it led to a discharge. What follows from that is the opportunity would have been lost for the appellant, if questioned, or to say, well, this is not true, and then the judge would have made an informed decision. What follows from that also is that the foreman, she was a part of the questioning. She was then asked if she was allowed to, if she could continue. She says, I'm only worried about the safety of the lady, the juror number 11. And she leaves knowing the information, and it's fresh in her mind and remains in her mind. We have no way of knowing but to speculate how much conversations outside of that would have gone to the other jurors. Then, moving back to the next inquiry number 3, it is the same forewoman, and more conversations about her role, and so the taint or the poison would have gone back as far as November in a 65-day trial and before juror number 11 left. So a proper inquiry could have found out, especially in a space where we do not know at what point or if any, when it is exactly the responses, or if the other jurors could have said that that wasn't the case at the time, if a proper inquiry and asking each and every juror, not even suggesting that it be done on the oath, but if it was asked what their responses would have been for the judge to make an informed decision. And I say this in the context that in light of the fact that our Constitution, it places even a duty on the judge to, as the custos morum of the Constitution, to protect the rights of the appellants, that it was incumbent on him to ensure that he makes the inquiry so he protects the fair trial right. So that would be in response to your question as it connects. It connects. So what flows from that then is when we get to the late retirement, we have a juror who is the fruit of the poisonous tree, or the introduction of the poison, no knowledge of how far the poison is. I'm not inviting the court to speculate, but that's all we are left to do, respectfully. And what happens in that situation is we don't know if the pressure arises because there was a situation where these jurors were able to say, I would participate in a bribe, allegedly, or not. And so the verdict that comes could never be a true verdict in light of that. So that's the submission as it connects from incident 2 to incident 3. Now, in relation to the proviso, and I think you had knocked some of the wind out of me, say, Lord Reed, because I would have borrowed your words in the judgment to say that you can't proviso unfairness, you can't proviso injustice. It's just not possible. It would be an absurdity in the law. Now, in relation to Lord Simler, Lady Simler, you asked a question about the balancing of rights, the balancing exercise. I would submit to you that the Jamaican Constitution, in particular the Charter, it came at a time post the Phipps decision. So there was a lot said about King and certainly Phipps, the Phipps judgment. But at that time it was presumption of constitutionality, and certainly the onus was on the appellant, to prove the privacy right violation. Post the judgment in Phipps, our legislators, which our parliament certainly has that ability to represent the people, and they would have thought that as a matter of public interest, the very right, the charter rights, in particular the communication rights, which is for all, the least among us has that right, was to be protected in such a way that where there is a breach of that right, it's a distinct difference. What difference is that, Lady Simner would have asked, is that the judge now has a duty to carry out the Oakes test, or the demonstrably justifiable test, because somebody says, and in response to Lord Reed, but the appellants are not here to complain of that right. But they did at first instance through their counsels collectively. And at that basic complaint about the right follows that the judge is to call upon the prosecutor to say that it is demonstrably justified because there is no issue before this court that there was a breach. The effect of the breach or the balancing exercise can only begin after the prosecutor has met the burden of demonstrably justifiable.
Can I ask Mr. Buchanan, while you're addressing us on the Charter, as I understand it, the Charter is formally, is part of a constitution. It was made part of a constitution by a constitutional amendment in 2011.
That is
right?
correct.
Was it preceded by some sort of review or report?
My learned friend, actually, Mr. Salty Casey actually made mention of the review and the report.
Oh,
but
right.
what is significant
check my notes. Right.
Right. What is significant that comes from it is that, and we take pride in this, and I'm quoting, I'm paraphrasing our Chief Justice, and it's found, thank you, it's found in the written case at 12 and 13. Yes.
Right, thank you.
Yes, but what we, as I was saying earlier, we take pride to say that this amendment, which is separate from any other Caribbean jurisdiction, was for us, it was made by us, and it was a testimony of our evidence of independence.
Yes.
Where we decided what rights would be protected, and especially the dynamics of the Jamaican society. Yes. Is the importance of protecting the least among us.
And was it intended that it be developed, I suppose, was it meant to be what you might call an autochthonous Bill of Rights, if we can call it that would be developed by the Jamaican judiciary in light of the circumstances in Jamaica, or was it intended to be influenced by comparative human rights jurisprudence looking at other charters of rights and constitutional guarantees in other countries?
I'm happy that you asked that question, because we did look, and I'm saying we because I take pride in being Jamaican, but we did look at other jurisdictions such as South Africa, and if you even the Canadian and the United States. But what you'll see, a clear indication, and again, my friend is indicating that it's in the written case at 20 and 21. Yep. But what's significant is that what is clear is that there is, similar to in the Canadian jurisdiction, that the test, which is the demonstrable justifiable test, is mandatory once there is a breach. And before us now is that there was a breach. The learned judge, and I will say this respectfully, this came at a time when the charter was very young. And so the contemplation to give effect to it, as judges do in interpreting the intent of the legislature.
Yes, and I see paragraph 13 draws our attention to what the Chief Justice Sykes has said, that it's autochthonous, which means it's indigenous, homegrown, originating with us rather than imposed from outside.
And what is key, which I will get to, and I agree with you, and I adopt the words of our Chief Justice, is the fact that after looking at constitutions all over the world, what we decided is what is important to us. So what we have is a section 13.2b, and I know there are many persons, I quote it so much that it becomes an annoyance to many, but 13.2, the protection given to every citizen under 13.2b. It is the last flicker or shimmer of light to what it is to be a human. Yep. And it separates the state clearly from the human being. And it says, listen, all state actors have a duty not to abridge, abrogate, or breach the rights. And when you do that, you must show that it is demonstrably justifiable. So in an answer, yes, thank you. So in an answer to that, ladies and gentlemen, that balancing exercise as to the evidence when it was asked about, especially in relation to what was on JS2, doesn't even begin to come up until after the judge would have carried out that exercise of the demonstrably justifiable test, and he did not do it. Yeah. So we have nothing on the record as to any submissions from the state, from the Crown, to say, here, notwithstanding, it is justifiable. There were less restrictive measures, or here's why there is a breach. So we don't have that before us, and that is the one flaw in the judge's acceptance. And evidence of that is he was concerned. He made words to my senior, Mr. Taylor, who is in the room, that if he was not daunted by the change in the charter, and the significance of it, the response at that level was nothing much changes even after the concession. But we do recognize the importance of it, but to submit to the court that the test wasn't done, and so there's no balancing exercise to which could have happened. And because this is our apex court, the apex court could not respectfully substitute what the judge at first instance ought to have done. And in those circumstances, the answer to question A, where evidence was collated, collected, and secured. So secured would have been the request from the police officer. The collection and collating would have been what flows from JS2, the cell site, the text messages, the call positioning, whatever flows from JS2. But all of that would have been no moment. And a key thing before I depart, because I don't want to take up too much time, or
well, you don't have a great deal of time left.
I was being cheeky, Lord Reed, but I didn't know you would figure me out. But the key thing in relation to that aspect is to understand that as we make heavy weight of JS2, what's incumbent on the judge was that in a demonstrably justifiable test, I would submit respectfully that in the absence of JS1, which was the controlled copy that the police officers did not have access to, and where the much counsel from the lower level, which Tom Tavares, KFC, would have said, listen, this is a man from Ireland who would have come to Jamaica, not given any effect to the right, and he gives testimony. This is Simmons, and he doesn't say whether he knows exactly what's in each and every file, and we have nothing to cross-reference, so they would have failed on that test. The last thing I will say before I take my seat, my lords and my lady, is in relation to the trial, the jury point, is I certainly, and I've read for this case about 4 years, in relation to the jury point, it has never been in the modern common law where a jury who we know for a fact is poisoned, is tainted, was allowed to remain on a jury, to bring a verdict, simply because the legislation would have prevented him from being discharged, where it is clear on its face that that juror ought to have been removed to protect the fair trial right. And it is in that vein that I will say that there is no cure, no proviso, or no thought of a retrial or a second bite of the apple where the unfair trial right was breached in the manner that it did in the circumstances from incident 2 to incident 3, and then the justification for breaching what we knew is common practice in the Jamaican space to ensure that you leave one sentence so that the deliberation takes place on the next day. And that would be my submission, that the conviction should be quashed or ought to be quashed, and I trust your wisdom on that. Thank you.
Thank you, Mr. Buchanan. Well, if we've heard all counsel on behalf of the appellants, then I'll turn to Mr. Knox. Now, Mr. Knox, I don't want to knock you off your stride before you've got started, but it would be helpful to us if you were able to address us first on the jury issues, and then we may consider whether we need to hear you on the JS2 issue.
My lord, yes. Doesn't knock me off my stride too far. But I have to read my handwriting, as opposed to the typed. Can I go first with the first of the jury questions that remain? And go first of all to E4072, 4072. Which is in bundle 5A, if anyone's working from a hard copy. And I would just like to show you what happened, because there is more to it than you were shown by my learned friend. The incident begins at 4072, 6th of February 2014, so it's about a month before the end of the trial. You'll see at the top of the page, court resumes at 2:25 p.m, but they're all in chambers with the judges, with the attorneys.
Yep.
And Marlene Catwell is the juror. And the first part I would like to take you to is at 4073. She says she said, perhaps I should just say, line 24, the witness, that's Catwell, one Friday. So it doesn't identify which Friday. When we weren't at court, I went to visit him, my son. We were supposed to go into the lobby, but him never come out in time. Just as him come out to me, Andrew St. John's came in that way. He saw me, he was a bit panicked, and I look at his face, and he was a bit panicked. It's not quite clear who he is, but perhaps she's talking about her son. And then she continues over the page.
Her son or St. John?
No, her own son.
But she says her own son didn't come out.
Okay. Oh, he saw me, sorry. In other words, St. John saw me.
Yes,
he was
I think so.
panicked, and I look at his face. Forgive me, my lady, yes. And then she goes on to say, shortly afterwards, when he came out, when he came out of the vehicle, my son came in and him said to me, inaudible. I was a bit angry with my son. I was a bit angry because he knew that I was coming and I didn't want to meet up with them, so I think his delay means that St. John's would have seen me. So I was angry at him. I think I must be her son now. You know me and I come back because him see me. I never related anything. But she then goes on to talk about her conversation with her son. Near the end of the page, me tell him me and a boy in the jail fight. Me go at the medical centre and him said to me. So there's been some sort of fight. And then over the page, 4074, she says, no, Kartel saw him and say him see him mother a juror, and say St. John's tell him, but him not tell the other rest of the man. So she seems to have seen, or rather, a Kartel appears to have been involved as well at some point. It's not always easy to understand quite what is going on. But then if one can drop down to the end of the page...
I think we can probably take it the judge understood what was going on.
The judge, I'm not sure he necessarily did. But towards the end of the page, 4074, they who? She says, the prisoners at the bar are there, and my son is there, and they know that I am a juror. If anything should go down, probably, I don't know, if anything go down, I would hate to know that me is the one who have to bury you. And he said, Kartel said to him, he was saying if. So her concern is being on the jury, and then if the jury convicts these defendants, then she's going to be in trouble. Or her son might be in trouble, rather. Yeah. It's not that she personally is going to be attacked, but she's concerned about staying on the jury, because if she does and the jury convicts, then there might be trouble for her son. That's her concern. Then you see Mr. Finson, that's Mr. Palmer's counsel. She don't even have to say any more. Juror Kartel said to him, if he. And then the judge says, okay, what I want to know, though, how you feel. You can bother with this, you can bother with the burden and all of this burial thing you talk about. The witness, Your Honour, the only thing I am concerned about is my son's safety. They are there, he is there, they know him. Andrew St. John's is on the said block. All right, that's a lot. Please just step down for us, please. It's too much for her. Having heard what she said, I have changed my opinion. yes, it's too much. So obviously at first he was thinking, this is storm in a teacup, but now he's thinking rather differently. And then the prosecutor, Mr. Taylor, does seem that concerns with her son, and if the authority can find a way to move her son from Horizon, my lord, so she could have peace of mind to continue on the jury, the judge says no, her son is now in the custody of the state. And then, yes, all right, the view is, Mr. Taylor, as prosecuting counsel, I wasn't trying to be brief and brush your comment aside, but from the performance that I saw her, it's clear to me for a parent to be placed in that situation that the body that she's sitting on may make a decision that may affect the safety of her son adversely. As a parent, it is an act that you don't want to place her in. In the circumstances, I don't think it's something she can properly deal with. You saw her performance just now. And then he goes on to say, therefore, I think I had better discharge her. And then towards 4077, towards the end of the page, Mr. Rogers, I think he's Mr. St. John's counsel, but I stand to be corrected. Another issue. For the record, I would hope that what has happened was not discussed in the jury room. And as a consequence of that, it might have been left with the rest of the jurors. I know it's a painful aspect at this point, but a real concern. May I inquire through the registrar as to any particular person in respect of the jury who would be seized of this information? Registrar, when the information came, sir, two persons spoke to me, that lady and the foreman, that forewoman. I inquired if anybody else is aware of the situation, and she said, no, just the two of them. So that would presumably be the forewoman and the juror.
Yeah. If you're going to read on, I don't think we need to read aloud the foreman's name.
No. My lords, my lady, if you could just read on to the end of to 4080, to the end of 4080, you will see what the upshot was and what takes place. So, my lords, my lady, what you get out of this is no one else knows except the forewoman and Catwell. It's not gone to the jury. And my lords, my lady, there's no reason at all to doubt that, because even the forewoman, I think, says she only found out on this very day. And then the judge finishes at 4081 saying, I'll make an announcement that she has a personal difficulty, and I'll dismiss her. Now, in my submission, there's nothing wrong with any of this. This is a perfectly sensible way of dealing with the matter. The judge has assured himself that no one else knows that there has been some incident. And I might add, the only, quote, incident is that she is concerned that her son is in the same, appears to be in the same prison as these accused. That's her concern. There isn't any concern, certainly on the face of the record, that her son has actually been threatened by any of the accused already. So there's no basis for saying that she would have, so to speak, spoken to other members of the jury and said that, or indeed to the forewoman. So I submit there's nothing here which required the judge to go any further than he did. My learned, I think, can I just ask you also to note that this incident began, I think, going back at 2:25 p.m., that's 4072, that's when the Chambers meeting begins. When you get to 4082, you can see the time at which the Chambers meeting finishes at 2:50 p.m. and then the court resumes at 3:16 p.m. Now, I mention that because it is suggested that the appellants themselves should have been in chambers at the time. Well, there are two answers to that. There was plenty of time for the appellants to be told, to the extent it was relevant, what had happened by their counsel. The gap between 2:50 p.m. and 3:16 p.m. The second point is, anyway, their counsel just simply didn't object to the course taken by the judge of holding this in private. Nor did they object to the course, the more general course the judge took of removing the juror. That's a point made by the Court of Appeal, and in my submission, that's a good point. And there's no reason to interfere with the Court of Appeal's judgment on this issue, which is referred to in our respective cases. Can I just also draw your attention now to the case of Bonnet, where a not entirely dissimilar thing appears to have happened, and it's in the electronic bundle at page 6287. And that's where the case is. Forgive me, my lords, I think I've picked up the wrong bundle. It's 6287. The relevant paragraph, if I can ask you to look at it, 6289, paragraph 21. And if I can just ask you to read that to yourselves.
Just paragraph 21.
Sorry, paragraph 21 and paragraph 22. Forgive me. And then 23. It's 21 to 23. In particular, 22 to 23. Where a similar sort of argument was run in slightly similar circumstances. 23 in particular. And the reason I draw attention to that is there are two things. First of all, it's up to the judge. When you get these unusual spin balls that come your way, it's up to the judge in the immediate circumstances to work out what is the best way of dealing with it. And I do submit hindsight and perfection are rather dangerous guides when that's the question. And that's the Orgles case. The second thing is the Lord Hope emphasises, well, in that case, the appellant had 3 previous convictions, and the idea was that the juror, knowing the appellant, might then have gone and told all the other members of the jury, to which Lord Hope says, but there was simply no evidence of that. So we're not going to interfere on that ground. And I submit, well, it's not identical, but it's a similar type of situation. So I submit, for that reason too, there's no reason to interfere with the Court of Appeal's view of that jury incident. If I can go now to the third point, can I just mention this? The judge, just basic facts, the judge persistently gave jurors very strong warnings right at the beginning of the case, and we set them out in our the main ones. Right at the beginning of the case, he emphasises to the jurors in terms that they are the judges. It's a phrase he keeps on using. You are the judges, and you must decide in accordance with your oath. And I think if I can just go to the key bundle of documents, and so we set it out, the relevant bits in our written case. At page 6236. And we give the references, but you can see paragraph 66, and then I'm ashamed to say 65, follows after 66. Those are the things he says right at the beginning. And 67. Now, so very clear direction right at the beginning. Decide in accordance with your oath. Don't speak to anyone whatsoever. And that's, you see, in the 2 references I give there. And then in paragraph 67, we give various other references. Every time he sends the jury out, he reminds them in terms, do not talk to anyone. You have a very serious function to perform. Don't go and mess everything up now, because it'll be fatal to this case if you talk to people. This is the drift, my lords. I have millions more references which I don't have to hand, but all the time he's saying to the jury, this is a very serious thing. You mustn't speak to anyone. You must remember your oath. And my lords, I say this is important, and my lords, my lady, I say this is important because after 56 days, the jury would have been well aware of the seriousness of their task, and that they must not talk to anyone, and they must decide in accordance with the evidence.
That's talking to somebody outside their number. What we're concerned with here is somebody within the...
I will come to what you might call the naughty juror in a moment. But I mean, obviously, it might be said he doesn't seem to have taken very much notice of it. I agree. I will deal with that. There is that point. But well, I'm talking for the moment about I'm going to address the points of law, obviously. But as a matter of fact, the jury had well impressed, and certainly the 10, if I can put it that way, the 10 had well impressed in their minds the importance of deciding in accordance with the evidence. Of that there can be no doubt. And throughout the trial, they are obviously very well aware of the enormous publicity this case is creating. They know they are doing a very serious job. It's not just a 1, 2, 3 day job, small case. This is the big case in Jamaica. It's on the news every night. Crowds outside the courtroom, crowds in the courtroom. They realise, so to speak, they are separate from the public. And that, in my submission, is an important point when bearing in mind whether the judge was entitled to trust the jury. I'll deal with about the miscreant. And in my submission, he was. He's given these directions. And they have, apart, of course, from the miscreant juror, there's no reason to doubt that the 10 have acted properly. My lords, my lady, the next point I want to emphasise, and I'll come to, if I may, the transcript, but the bribe was offered by the miscreant juror on behalf of, or rather in the interest of, all 5 defendants, including Shane Williams. Now, you can see why I emphasise that, because the jury obviously did not convict Shane Williams, or the 10 didn't. He was acquitted. And I'm going to come in a moment to the transcript, if I may. But while I'm on that point, the Shane Williams point, Chow gave evidence of a fight, or the attack, in which the 4 men apart from Shane Williams were involved. In other words, Shane Williams was not himself implicated by Chow in the actual killing. What he was implicated in was that it was said Chow gave evidence that Shane Williams, who he called Terence, was one of the men in the video talking about a killing. And that was the basis on which the case went to the jury. So there was evidence, the judge did allow evidence to go to the jury in relation to Shane Williams, but it wasn't what you might call the same evidence Chow gave against the other 4 men. If I can just give you the reference for Shane Williams's involvement, or rather Chow's evidence of Shane Williams' involvement, it's at E4011. And so Shane Williams is one of the people identified in the video, which was said to be incriminating. That was the case against him. But I do submit it is important that that is an indication the jury were not just saying to themselves, I see, a bribe has been offered on behalf of all of them, so they must all be guilty. The jury has distinguished between them.
Are you going to take us to the references to the 5, to the bribe being offered on behalf of all 5?
Oh, yes. yes. Because I would like to go to, it's not a very long transcript, I would quite like to go to the transcript to see what actually happened in front of the judge. I'd like, if I may, to go to the facts first, and then I will deal with the issues of law which arise as a result of them. The transcript is at 5.1, begins, the relevant part, I think, is at 5.167. I should say, actually, 5164 is where the Chambers meeting begins, 2:20 p.m. on the last day of the trial, or rather, last day of the summing up. 2:20 p.m., court resumes, and the judge then reports that he's heard that an offer, a member of the jury has been offering a $500,000 bribe to do a particular thing. You see that about a third, halfway down. My lords, my ladies, just for information, the exchange rate at that point was in pounds, 180 Jamaican dollars to £1. So we're talking here about, I think, something in the region of £2,700. That's the total number.
So I think I'm on the wrong page. Which page are you on?
5164. Forgive me, my lord, I did say 5167, then I went back to 5164.
I'm now back. Thank you.
So that's the size of the bribe, if I can put it that way. I'm not saying that makes it any better, but obviously not. But on the other hand, it's not such a gigantic sum as to lead to the conclusion something that, well, there can only be an incredibly rich person who's offering it. So the judge says, well, I've heard about this bribe, apparently, and he explains how he's come to hear it. And then at 5167, or 5166, you'll see that the DPP has been called in, about a third of the way down the page. Now, she didn't present the case for the prosecution, but I'm told by her, she's in court at the moment, Ms. Paola Llewellyn, that when this incident arose, the judge called for her, if she was available, to come along, as did indeed the deputy DPP. And so she turned up, because obviously this was a difficult incident to know what to deal with. So you see there, 5166, she's come along. And And then you'll see what she suggests at the foot of the page, 5166. Judge, it's dependent on what your lordship decides. Clearly that's the issue. We'll have to go to another domain. That's between her as the complainant, the particular person. If there's to be credibility in the matter, that's not for you. It's a very serious matter. So she's not encouraging the judge, so to speak, to make any further investigations into this. I submit quite rightly. Judge, if that report is credible, and having heard the thing, one decision will have to be made in respect of that man today. He's going to have to make up his mind now. DPP says yes. And then the judge says, this is all very painful, but I'm going to have to arrange for Madam Foreman to come into the into chambers. You see that about 2/3 of the way down the page. And then the Madam Foreman...
Do we assume that during that period of time, who else has been... Is there any indication who else is with the judge and the DPP?
I think all counsel, I should say, as I understand it, all counsel are present, but not the appellants themselves. I don't think there's any issue on that.
Right. Thank you. Doesn't actually tell us, does it?
You're right, my lord, but I have a feeling, I don't think it's in contention.
Thank you.
And before he says that he's going to call Madam Foreman, he says that he's going to summon that juror, and he's had instructions to the police.
Yes. In fact, he never does.
Yes.
But he does get the foreman, Madam Foreman, along. And so she turns up. I'm now at 5167 at 2:43 p.m. Judge, you can see what the judge says, 5167, line 19. And if you can, maybe simpler, my lords, my lady, if you read on to 5173, rather than me picking up bits here and there, because there may be other things which I miss out, which you might want to read.
To which page?
5173.
Thank you.
And then I'll make some comments on it.
Yes.
My lords, my lady, if you're ready. If I can just draw particular attention to the following points. First, at 5168, my learned friend is quite right, and he says, the contact was made with me today, so she finds out today. However, the contact has been made over a period of time with other jurors, and they confessed it to me. However, I cautioned them and told them that we are going solely on the evidence. I told them not to be swayed, that's the word, not to be swayed with what is being said, and they cannot be intimidated by what's been said either. So they're okay. And then she goes on to say how the bribing juror got in touch with her and seemed to be frightened of her at first, or frightened to do so at first. The second point is at 5170, at the top of the page, he called me out. That's bribing juror. We were in the room. He said he needed to talk to me in the jury room. I asked him what he wanted to talk to me about. He said to me that he knows that I'm influential and people listen to me. I said it's not about listening to me. It's based on whether I pointed them to the facts of what we hear, not to be influenced by what is outside. He said to me, well, he needs me to do him a favour. And then dropping down, I asked him what was that about. He said that we should go to lunch. I said, no, I can't leave because I have things to do and I have somebody coming to me. Basically, he said, I should convince everybody to release, and then, in answer to my Lady Simpson's point, the men at the bar, not at the bar. And then over the page, 5171, judge asked of the forewoman, you knew him before you came on the panel? No. I met him here, but when we met, that's when my suspicion of him grew. We started watching and observing his actions from there, because initially he was mad. They chose me as the foreman. He went to everyone and tried to ask them to make him the foreman instead. And basically goes on to say, it's a duty, and we don't, being the foreman doesn't mean I'm going to have tea in the judge's chambers, eat crackers and go for lunch, which is a duty. So that's what she's saying. So what she's saying, essentially, is he seems to have gotten to the head that he wants to be, as well, the big chief. He's disgruntled about this, and she just took no notice. But importantly, towards the end of 5171, but over time he recognised that, okay, fine, before he started going to these persons and telling them that, listen, this is what we need to do, I would say, you are listening to the evidence. He said, no, we just need to let go de men, again, them. So when we speak today, he said to me, that's what we need to do. And he says she says the conversation went on for 5 minutes, and she repeats the £500,000 figure. Then towards the end of 5172, he says, as Mr. Southey rightly pointed out, Madam Foreman, 11 of us. He spoke to 11 of us. That would probably suggest, therefore, the discharged juror. He spoke to 9 persons first. The thing is, nobody's listening to him. Because nobody's listening to him, he wants me to speak to them. I do emphasise that. So I'm not listening to him either. That's the reason why I got him on tape. But the trouble was, the tape wasn't particularly clear, so it never got played. And then you'll see at Madam Foreman leaves at 2:52 p.m. Now, I emphasise that because she leaves in advance, and the summing up doesn't resume, I think I'm right in saying, until about 3:20. So there's plenty of time for her to inform, because she's bound to inform the jurors of what has happened, that she's been to see the judge in chambers. And you'll see 5173, the DPP says to the judge, I wonder if you can allow each team to discuss for 5 minutes. I will wish to speak, and I'm sure my learned friends will wish to speak, perhaps 5 minutes. So again, the reason I emphasise this is there was time for the appellants to speak to, or rather the appellants' counsel, to speak to the appellants themselves. And then the DPP, towards the foot of 5173, recommends to the judge, just warn them again about their oath, just their oath. That is what she is suggesting. And then over the page, Mr. Finson, Tavares Finson, you'll see 5174, the DPP at the top, repeats, as far as the prosecution is concerned, we're prepared for the matter to proceed. Just remind them of their oath. And then Mr. Palmer's counsel, we're of the view, don't see how you can proceed in these circumstances where you've got one person who is making an allegation that someone's going around offering the jurors money. She obviously has some tape, her role. So he seems to be objecting, not on the basis that, so to speak, there's a corrupt juror who is on their side, but rather he's rather concerned about what the forewoman is saying. But in any event, Miss Llewellyn then says, the DPP says, in fact, it's the prosecution who is most at disadvantage by carrying on. And in my submission, that's obviously right, in principle. There's one person who obviously wants to let these people off. There is a risk that he is going to be persuading others, or has persuaded others. And then you'll see at the end, at 5175, the matter ends at 3:07 p.m. And what happened immediately after that is when the summing up resumes, the first thing the judge does, I think I'm right in saying, is remind the jury, if I can just dig up my reference, I hope this is right, 5149 at 3:22 p.m.
Just remind me, Mr. Rogers was representing who?
I think it's St John.
Right, so you've got Mr. Finson not exactly agreeing with the...
Finson's for Palmer.
Yes, I see. But you've got both Mr. Finson and then Mr. Rogers raising, on the face of it, objections.
Concerns, yeah. I would have to accept. They're saying we're not very happy about this. And I think one of them says, I'm concerned about the overcompensation point. And maybe Mr. Rogers says there's a risk of overcompensation. That is to say, the jurors will swing too far in favour of the prosecution because of their knowledge of the bribery attempt. Can I just mention one point before I go to what the judge does? I should have made it before. It's not clear whether, and there was no investigation, whether or not the bribe was coming from the appellants themselves. And that's why I mentioned the figure of £2,700 equivalent. It may just be this particular person was, and don't forget we're talking about very famous people, he's a particular aficionado, we don't know, of Mr. Palmer's and Mr. Campbell's work. But in my submission, what the judge has done, subject of course to points of law, is in my submission, again, very difficult circumstances, but perfectly sensible. He's called in the relevant parties, and on the face of it, the party most affected by the problem, the prosecution, is saying, I'm prepared to carry on. And the reason, of course, for that is that this is day 56. In practice, it will be, or may well be, very difficult to get a retrial of this matter. Another 56 days, you're going to have to get Mr. Chow to come along again. I would hope that you could take judicial notice of the sheer difficulty, certainly, in relation to some of these witnesses coming along again and arranging things. So on the face of it, it's the prosecution who's saying, I'm prepared to take this risk. And the first thing that then happens, going back to page 5149, is the judge reminding the jury at lines 3 to 13 of their duty.
He doesn't say there that they shouldn't hold anything against these appellants.
No, he doesn't. But, my lady, I would submit it's obviously implicit. I mean, the context here is that the forewoman's been called over to see the judge to talk about the bribery, and she's been told to go back and tell the jurors to deal with the matter in accordance with their oath. And they, of course, will know about these allegations of bribery, because it's said that the bribery has been offered to all of them.
So he can delegate his duty.
Well, my lady, my learned friends like that. But no, I'm not saying he can delegate his duty, but it's quite clear that he's taken a favourable impression of the forewoman, and it's quite a sensible way. He's not delegating, but he's saying to the forewoman, you tell them, as you have been already, you decide in accordance with your oath, and then he reminds them of exactly the same thing when you get to 5149. I agree he doesn't mention, and my lords, one can see why. He doesn't specifically mention, I gather someone has been bribing you. He's in a difficult position, whichever way he goes. And I submit it's a perfectly fair thing to say, I'm reminding you of your oath. It's an oath to decide in accordance with the evidence. And the jurors would have known that was their obligation.
Sorry, which page were you on? when you're saying that he immediately tells the jury?
5149. The summing up resumes at 3:22 p.m. 5149. So the first thing he does is tell the jurors after the break, which everyone knows what it's going to be about. First thing he says, decide in accordance with your oath. In my submission, economy sometimes, just making the main point, is the best course. And this, in my submission, was a perfectly reasonable course for the judge to adopt, because everyone knows what he means by this. Can I just also emphasise that subsequently, at 5157, the judge repeats the direction he had already given, but importantly, he repeats at 5157, decide the case against each of these defendants separately. That's 5157, lines 10 to 18. And he then goes on at 5159. He gives the standard directions about reasonable doubt. At 5159, at the invitation, I think I'm right in saying, of the Deputy DPP, who was back in the seat, so to speak, he gives good character directions at 5159. I think those good character directions applied to all the defendants, bar one. It may have been Mr. Jones, I'm not quite sure. Now, I mentioned the point about Shane Williams being acquitted. That, in my submission, is not an insignificant point. There are ECHR cases, which I don't have immediately to hand, but I'm sure I can find them in a minute, where problems have arisen, where the jurors have reported to the judge that one of their number is making racist comments. And there was one case, I will come to it in a moment, where there were two defendants, and they were both Asian. And the report gets back to the judge, I'm very worried about this. This chap keeps on making racist comments to that effect. But the jury convict one, but acquit the other. The matter goes to Court of Appeal, who say, well, there's no doubt there was reason to suppose bias, but on the other hand, the judge gave directions to follow your oath. And the matter went to the ECHR, who took the same point. And they said, well, the judge did what was necessary, reminded them of their oath, and you can take into account the fact that the jury don't seem they do seem to be able to distinguish between the guilty and the innocent. My lords, my lady, if I can perhaps just have a moment, or if I can remind you of what that was in a moment, but I submit that is important. One cannot simply ignore the fact the jury, on the face of it, have performed their duty. They've put this evidence, they've looked at the evidence, and they've acquitted one person on whose behalf or in whose interest it was said this bribe is being offered. I think the name of the case is Gregory, but I don't have it. I don't have the reference to hand. Gregory. So that's what I want to say about the facts. Then I come to the issues, if I may. I say there are two issues. The first is, was the judge obliged to discharge the jury? Did he have to? Did he have no real choice as a matter of law? The second issue is, if he was not obliged to discharge the jury, was the procedure he followed sufficient to ensure that all the defendants received a fair trial? Now, the first issue in my submission raises in turn two questions. The first is this: was the judge obliged to discharge the jury on the basis that there was good reason to suppose that one of them was biased in favour of the defendants, or indeed all the defendants, regardless of the prosecution's willingness to continue? In other words, just as a matter of law, was the position such that, look, you haven't got 11 impartial jurors here, we know you've got one bent one, he's bent in favour of the defence, but you have to discharge? And that's the first question as a matter of law. Notwithstanding the prosecution's waiver, if I can put it that way, of the point. That's question number one. The question number two is, was the judge obliged to discharge the jury on the basis that realistically the 10 jurors, the non-bribing juror, the other 10 jurors would consciously or unconsciously be prejudiced by their knowledge of the offers of bribes, prejudiced against all the defendants, regardless of the directions that he had given, or indeed could give, to tell them to abide by their oath. That, in my submission, is a separate question.
The way it's put in Putnam is a real risk that they might have become consciously or unconsciously prejudiced.
Real risk they might have become. That's why, forgive me, my lord, that was I was trying to go by the Putnam test, consciously or unconsciously. Is that something which is going to be in the back of their minds, come what may? Now, on the first question, namely, you've got one rotten apple here, so that's it. We say that can't be right. We have in our written case drawn attention to the case of Brown, which is in the electronic bundle at 6329, paragraph 31, where a not identical thing happened, but the problem arose, what is a judge to do? Or rather, the point was made that the defendants cannot derail trials just by making offers of bribes to juries and so forth. It's not on all fours, but I submit it is important all the same. So it's 6329. And it's paragraph 31. We fully understand any judge's reluctance to discharge a jury in circumstances for which a defendant bore material responsibility, although there are no doubt gradations of responsibility, starting with deliberate misconduct by a defendant aimed at achieving a discharge in circumstances where a trial is going badly, or at achieving a favourable verdict and ranging downwards in seriousness from those situations. Counsel for the appellant thus, rightly in our view, accepted before us that it cannot be open to a defendant to obtain the discharge of a jury by deliberately creating some ground of aggravation or discord between him and the jury, whether inside or outside court. But in order for a judge to rely on the appellant's responsibility for events occurring as a ground for not discharging a jury, the circumstances giving rise to such responsibility must, it seems to us, either be agreed or ascertained by the judge to exist. They cannot be assumed simply because it's a prima facie case. Now, that's not on all fours, but I submit the basic point is this. It's not open to either a defendant himself or, indeed, a juror acting, if you like, without instructions from the defendant, but nonetheless in the defendant's interest, to derail a trial. And I submit that's an important point, and I submit it also goes to the whole jury system. And it will bring the jury system into disrepute in a case such as this. If the position is really this, there are 10 innocent jurors who have performed their duty, let's assume for the moment, who have performed their duty without any shred of bias. It would bring the system into disrepute if the verdict is nonetheless to be set aside because of the one bad juror who was not obeying his duty. I submit that would be, one can understand what you might call the purest version of that. One can understand, of course, the notion that a jury has collective responsibility. But in my submission, that would be would strike, I submit, what you might call the man in the street, the sensible man in the street, as a remarkable result.
But the normal scenario would be that, of course, you'd get rid of that juror.
I agree. The difficulty here...
I mean, you wouldn't say, well, you can carry on with that juror.
But I think, my lords, I'm bound to accept that we don't know, of course, but obviously what concerned the judge is, I don't think I took you specifically to it, but he does at one point say, what am I going to do? Either I let the juror out, in which case the case can't continue, or it carries on. I accept what your lordship says, but my lord, again...
But what I'm saying is the quote from paragraph 31 leads us to the obvious result that, of course, a juror who's refusing to obey directions has to go.
He has to go. Well,
that doesn't then follow that, oh, you can leave him on.
No. Subject to one point, what I call the waiver point. And the prosecution here, it is, as they pointed out, they're the losers in this. And they are prepared...
How can you be sure? You just don't know. You don't know.
Well, my lady, funny enough, we do know in one sense because it was a 10-1 verdict, and we know from evidence acquired afterwards that you-know-who was the one. I don't think there's any doubt about that. And that was a matter of witness evidence obtained by, funny enough, the defence afterwards.
Yes, so but if there's a... Well, I think the point that her ladyship is making is that one doesn't know how people may react to an attempt to bribe them. If the jurors thought that an attempt was being made to bribe them on behalf of the defendants, then that might have, who knows, it could have inclined them to dig their heels in and prejudice them against the defendants.
My Lord, I agree. That, of course, is the second question. I'm just on the first question for the moment. Can I, namely, there was just a rotten juror. Does that of itself mean the verdict cannot stand? And can I give you an example where I submit it is not of itself a sufficient reason? Supposing what happens is this. A jury comes in with, let's say, a 10-1 verdict. The one has been bribed, but the one has not revealed that to anyone else. It all comes out after the trial. Can the defendant come along after and say, oh, dear, there was a rotten juror on that, he didn't tell anyone about it, but nonetheless the verdict must be set aside because there was just one, as well, there was one person who wasn't performing his duty, qua juror. My submission would be that would receive short shrift from the appellate court. It would say, well, the rotten juror didn't speak to anyone, he didn't obey his duty, he did come in with a not guilty verdict because he'd been bribed, but on the other hand that made no difference whatsoever to the 10 who did come in with a guilty verdict. We know it didn't because he didn't even mention it. Now in those circumstances I submit the verdict would stand, and I simply give that as an example as to why what you might call the pure point, there have to be 11 good jurors even when there's a 10-1 verdict and the 10 are good. There have to be 11 and the whole thing falls to pieces. Cannot be right. And I submit that, in the example I've given, that would give rise to very considerable public concern.
But the trouble is, we don't know.
I've got to add that.
We're not supposed to know.
Well, I know we're not.
Who's saying what in the jury room? So you can never. So the hypothetical you're given can never arise in reality.
Well, my Lord, I hesitate to disagree, but I would submit it could arise, and indeed, in this case, we do know precisely what happened.
Yeah.
I mean, supposing Livingston came, for whatever reason, supposing he had not mentioned any of this to the jurors, but afterwards it came out that he had actually received bribes and was convicted. But let's just say, or he had received bribes from one of the defendants. So it's not on all fours, but I'm simply at the moment on the point, do there have to be 11 good jurors, full stop? And if there's one bad juror, the whole thing falls away. I submit that's not right. The other question is the different question entirely, namely, what about the 10 good jurors saying to themselves, well, you know, obviously, they're all bent, these people. And so I'm going to hold, it's a sort of little bit of prejudicial information which they're holding against the four appellants. That's the question. Now, my respectful submission on that is, as well the second part of the question, is this. The question is, was the judge bound to assume, in all the circumstances, that whatever directions he had given, or could give, was he bound to assume that the taint, if I can put it that way, of the bribing juror was never going to leave the minds of the 10 good jurors, such that, maybe even unconsciously, they would hold this against the accused?
But isn't that the wrong way round? Doesn't he have to be sure that there isn't that risk, rather than the way you've put it?
Well,
he has to be sure that there won't be, that justice will be done,
yes,
rather than the other way around.
My lady?
I'm trying to say.
Yes, I'm bound to accept that. I maybe have too many double negatives in what I was saying. I accept he has to satisfy himself that he is in a position, given what he's already said and will say, to ensure that there will be a fair trial for the other appellants. Yeah. That's the question. And in my submission, it's a question of fact to an extent, but on the facts I submit he was entitled to come to the conclusion that the 10 jurors, with proper directions, would not take into account the fact that one of them had been offering bribes. And that, in my submission, was obviously a matter for the trial judge himself to assess, and that's how he assessed it. And my lords, my lady, I also rely on the fact that the Court of Appeal upheld the judge's judgment on this point. So what you would be effectively doing is saying to the, as were the local courts, they were wrong to hold that justice, there could be a fair trial, notwithstanding.
But the Court of Appeal appears to have been comforted by the fact that there was nothing to be gained by questioning or looking into the matter any further. At best, a denial of bribery, and a great deal that would have been lost, the possibility of having to discharge the whole jury. Was that the right approach?
Well, my lady, I think one has to bear in mind what was being put to the Court of Appeal. I think from recollection, what was being said to the Court of Appeal, and is not so much being said now, is that the judge should have carried out an inquiry. He should have made more inquiries. My answer to that is that if the judge was satisfied that a direction would put the matter right, then he was entitled to take that course. I agree. The question is, could he rationally be satisfied? You might say if he couldn't rationally be satisfied, well, that's that. But in my submission, he could be, for the reasons I've already, in a sense, gone through right at the beginning. He has reminded the jury of the seriousness of their role and the importance of deciding in accordance with the evidence. He's told them again and again, you are the judges, you are not to speak to anyone. They are well aware of their special position. And I submit it's quite often the case that prejudicial information comes out in the course of a trial, which gets in front of the jury, and as long as a judge's direction, I'll come on to the direction in a moment, as long as a judge's direction is sufficient to ensure that the jury will decide in accordance with the evidence and not in accordance with the unfair prejudicial material, then he's entitled to take that course. And my lords, my lady, obviously one can well understand, of course, the concern in this case. Of course, that it might be said, well, who could forget? But my lady, my lords, I submit it's not that difficult. Jurors have to be trusted to act in accordance with their oath. And I want to take you to a case about that. It's a cardinal principle that jurors do act in accordance with their oath, and act only in accordance with the evidence. And if I may, can I take you back to the case of Bonnet, where Lord Hope makes this point, and he refers to other cases of higher authority, which say the cardinal principle of jury trial is that jurors act in accordance with their oath. They're not nincompoops.
Can I just ask you, in the context of your submissions, do you see any role for the Porter and McGill test?
It's fair to say that where I'm putting it is that the question is whether there was a fair trial or not. And in my submission, if one could be satisfied that there was a fair trial, that is that. I mean, in one sense, I accept that what I'm saying is that if the court is satisfied there was no risk of well, in one sense, Porter and McGill is to do with a real risk of possibility that the tribunal is biased. But it's not the appearance so much, but there is a risk of possible bias. And to that extent, I accept Porter and McGill is right, because in my submission, what the judge did was to remove any risk of possible bias. It's not quite the same way as the Putnam test, but it comes to much the same. But appearance of bias per se, I submit, is not the relevant test. The question is, was there a real risk or possibility of bias?
And you say he removed that by the direction he gave at 3:22?
And also by what he'd been telling them before. It's the whole thing has to be looked at. It's often said in the cases that the judge is entitled to look at, the judge in making these sorts of decisions will bear in mind his view of the jury, so far as he can tell, over the course of the hearing. And in my submission, he was entitled to take into account also what the forewoman had said to him. And I do submit, if one asks, and looking at everything, if one looks at A, the verdict, B, the letting off of Shane Williams, and C, the evidence, which I'll come to later if I may, which is simply overwhelming, one asks, what unconscious bias, so to speak, added to all the evidence which was there anyway? How could it have done? And that is the point about the strength of the case. One can see where the evidence is equivocal and so forth. One might say, well, that's rather harder to tell. But if it's 2 and 2 equals 4, well, there is in my submission a basis for saying the risk of a possibility of bias it has been removed, or is not likely to have affected the jury's verdict, or won't have affected the jury's verdict. Can I just take you to the Bonnet and Taylor case? Because it is important at this point, to what extent can you trust the jury to act properly and in accordance with their oath? And we looked at one passage already. It's at 6291. Paragraph, I think I'm right in saying, with 6290 one can begin at, paragraph 24. There was, however, another course that the judge could have taken, and did take in this case. That's to say, not making further inquiries about the juror. At the outset of his summing up, he gave the usual direction to the jury. It was for them to decide what evidence to accept and what to reject. He then gave this direction: decide this case on the evidence and only on the evidence. Do not be influenced by anything you might have been told by anyone, whether by some fellow member of the jury that sat or are sitting with you about some prior knowledge or feeling or view. That is unimportant, and if you act upon that, justice will have miscarried, because that's not the evidence. I hope that I'm making myself absolutely clear that it's the evidence and only the evidence in this case that you have heard that you're entitled to act upon and determine. Having looked at the evidence, examined it, weighed it, determined what facts are, and ultimately what your verdict is, after applying the law, and I will give you to the facts that you find proved. Now, I agree that's a stronger warning, but nonetheless, it's to the same effect. Then, the important passage in paragraph 25. The assumption must be that the jury understood and followed the direction that they were given. See, a judgment of my own, as it were. In the Supreme Court of Canada, in Corbett, Chief Justice Dixon said that the experience of trial judges is that juries perform their duty according to the law. In the High Court of Australia, in Denham, Mason CJ and Toohey J said that the law proceeds on the footing that the jury, acting in accordance with the instructions given to them by the trial judge, will render a true verdict in accordance with the evidence. To conclude otherwise would be to underrate the integrity of the system of trial by jury and the effect on the jury of the instructions by the trial judge. In the Irish High Court case of Z, Hamilton P. expressed confidence in juries to follow the directions given to them by the trial judge. The direction which the judge gave in this case was clear, understandable, to the point. Board is satisfied that it is sufficient to deal with any risk that the juror who is excused might have said something that the jury ought not to have been told. Now, of course, my lord, everything turns, in one sense, on the facts of a particular case, but I do submit it as a fundamental principle that you trust the jury to act in accordance with their oath. And it is implicit both in the judge's decision to leave this matter to the jury and in the Court of Appeal's decision that they were satisfied with their knowledge, if I can put it this way, of how juries work, that they would have done.
And does it matter that, I mean, inevitably you're focusing on the 10 because he didn't trust the 11th. He had the police ready. He said he had the police ready.
I accept that. That goes back to my answer to the first part. I accept he
But does
probably
it
doesn't.
matter for these purposes that it's effectively he's trusting a jury of 10,
Yes.
and 10's not a jury within the Jury Act in
Well,
Jamaica, is it?
One then gets into what I call a rather metaphysical argument about what is a jury. Clearly, it's 11 people who walk into court. About that, I go back to what I call the first question. Is it really the case that there is no jury if it turns out afterwards that one of them had taken a bribe and was going to acquit come what may?
That's if it turns out afterwards.
Yes.
What if you know going in?
If you know going in, I submit the same follows.
The same.
The judge is entitled to say this. A 10-1 verdict is a good verdict. It's authorised by law. I have good reason, I'm just, as it were, expressing in words what no doubt the judge would be thinking. I have good reason to trust the 10. They will follow my directions. That is good enough to satisfy the requirements of the statute, that there be a jury who decides this. Because there are 11 altogether, and if there are 11 altogether and one of them still takes no notice of what I say, well, so be it. But my Lord Lordbury put the point at the beginning. It's quite a short point, but quite an important point. But I do submit the crossover between these two questions does arise, but I suppose it's very important to keep them separate. Because if I'm right in saying that a verdict by 11 men, or 11 men and women, one of whom is bent, is a good verdict at the time, then that's a good verdict. If, on the other hand, it's clear that there's a real risk that the 10 might have been influenced by the one, then I accept that might be a basis for setting aside the verdict.
Just starting with the one, you say that the judge can choose to leave somebody on the jury, notwithstanding that he knows this person is corrupt. Presumably, it's the same if he knows that the juror is mentally ill or communicating with the deceased via a Ouija board or has been looking up the internet. So it's the same, is it?
No. No, my lords, it wouldn't be the same. If I may, no. The important point here is the prosecution knows the problem, and in the passage I took you to, the prosecution says we're the ones taking the risk.
Well, but they can't waive the public interest in the administration of justice. It's not a matter.
Well, the difficulty, my lords, if this had happened on day one, it would be a very different position, obviously.
You're really just postponing the question. So, on your view, can the prosecutor decide that it's okay to allow somebody to remain on a jury, notwithstanding all the scenarios that I've put to you, and the judge can go along with that?
In my submission, in the extreme circumstances of this case, yes.
And how many jurors can the judge allow to remain on the jury, notwithstanding his knowledge that this one's mentally ill, that one's been bribed, the next one's in touch with the deceased via a spiritualist?
Well, no, of course, he can't. Right. The whole problem in this case arises because there were just 11 left. That is where the problem arises from. And my lords, of course, I can see one can think of any number of examples, like the Lordship is putting to be saying, well, in those circumstances, surely the prosecution couldn't just waive it. But this is rather different. This is right at the end of the trial, enormous expense, 56 days, the evidence has all come out, the summing up has been done, and then, well, one thing comes out. Now, in my submission, the question is simply this. I mean, it does get to this point. If I'm right in saying that a verdict of a 10-1 verdict of 10 good people and one bent person is a good verdict as a matter of law, then the judge is entitled, and the prosecution is entitled to say, well, I dare say that person won't obey his oath, but I'm satisfied the other 10 will.
But that's assuming there's going to be a conviction. And the jury has, if it's going to acquit, is going to have to do it by, is it an 11-person jury is going to have to do it by a 10-1 majority. And how does the judge know? Well, it's likely that there will be 9 good people and true and 1 crook in the 10. It's an acquittal.
Well, my lord, if in my submission the judge The fundamental right is to a fair trial for the defendants. If the prosecution, and in one sense, this whole case comes down to one point. Can the prosecution say, I know there is this one person who seems to be offering bribes, we probably can't trust him, but I'm prepared to carry on and take that risk. Is it open to the prosecution to do that? That is the question. That's what the prosecution did. And in my submission, the answer is yes. There's no authority, if I may, with great respect say, that says, no, the prosecution cannot do that, because that would deprive the accused of an unfair trial. I also make this point. The question is not, so to speak, at the very moment this all takes place, but looked at broadly, looking at that verdict. Have the defendants received a fair trial? If one is satisfied the 10 were not influenced. I agree, obviously, that's a separate question. But assume for the moment that the 10 applied with their oath, they acted properly. Is it really to be said that that was a bad verdict and the defendants must be acquitted or the appeal must be allowed? I submit no. That, I do firmly say that would bring justice into disrepute. 10 people have done their duty, one person has messed it all up, but the verdict is a good verdict at 10-1. Why does it matter if the one has brought disaster? That brings the jury system into disrepute. Our learned friends, of course, rightly say that in England we don't have that problem. But this is a common law point. And the question is, what is the common law in this situation? And that's why I urge upon your lordships the point that I'm making. I fully accept you've got the separate point about who knows what was going on in the back of the jurors' minds. That's a different point. But my point is just on this, what you might call the degree to which there have to be 11 people on the jury. The fact is there were 11 people on the jury. That is my short answer to this. One of whom, at the time, there was good reason to suppose wouldn't act properly, and who we now know didn't act properly. I submit that's not a conclusive answer. And
Can I just take you to, where we got to, I think, which was paragraph 25 of the Bonnet-Taylor decision, page
yes.
6291.
Yes, thank you.
Lord Hope very clearly says that the direction which the judge gave in this case was clear, understandable, and to the point. And we look either earlier at what was being put forward as the defence, as the direction.
Yes.
Don't allow anyone that you sat or sitting with about some prior knowledge or feeling or view, that's unimportant. In other words, he's directed the jury to the specific problem. Now, just to say you've got to carry on with your oath seems to me non-specific. It is not to the point. It doesn't make clear to the jury precisely what the judge is wanting them to do.
In my submission in this context, it does, because they will all know there's been this half-hour break in the summing up, while form has been called away. She will have told them, because the judge says, tell the others. She will have told them what's happened. And, my lords, I fully accept, of course, one might say the direction could be more forceful. I accept that. But the question is, was it sufficient to ensure the fairness of the trial, given everything else which I've mentioned? And in my submission it was.
But all I'm saying to you, putting to you, is that what was said by Lord Hope hardly supports your case, because this was not a specific direction.
Well, my lord, not express. I don't want to, as it were, quibble. I accept it was not specific, and of course it would have been better were it this specific. But the question is, was the direction given by the judge taken together with everything he had already said, and the juror's sense of responsibility, was it sufficient? But of course this is a different point. My submission is it was, in one sense. I take your lordship's point. It's not specific in the way this was, but in my submission it was sufficient.
I'm not sure that it. I think you probably have dealt with this point, but it strikes me. But when you say this is a question of common law, I don't think it's purely common law, because we do have the statutory provision.
Yes.
It's on page 6803.
Yes.
Which tells us that 12 jurors formally array in a case of murder, and then says in subsection 3, where in the course of a trial any member of the jury dies or is discharged by the court through illness or other sufficient cause, the jury shall nevertheless, so long as the number of its members, so it's a proviso, so long as the number of its members are not reduced by more than one, be considered as remaining properly constituted. Now, it might be said that the judge, as it were, can't sidestep that provision by failing to discharge somebody where there was indeed sufficient cause to discharge them. If he discovered, for example, that the person, the person had been bribed or was the defendant's brother-in-law or whatever you like.
Well, in my submission, that wouldn't be the correct construction of this. In one sense, you have my point. As long as there are.
I mean, you were saying it's just a question of counting the number of live bodies on the jury, and
that's all it's saying.
Yeah.
Well, my learned friends, in my submission, that's what it's saying.
Yeah.
Yes. And my lord, after all, one doesn't know. I mean, at the time the judge gives his direction and decides what to do, he might be hopeful, hoping against hope, so to speak, that the miscreant juror will actually just see sense. But it doesn't follow, in my submission, from this act that the judge is bound to get rid of that juror. That's the question. But I agree, if he's bound to get rid of that juror, he's bound to bring the case to an end for that very reason. And my lords, this is why it is a short point, but in my submission a difficult and interesting point. I haven't addressed you on the proviso and things like that, but I'm conscious of the time. But I wouldn't mind showing you some of the evidence. I mean, it is, because I do connect it to my point. Well, there was no need for any, if I can put it this way. Anyone looking at the evidence would say, I couldn't care less about these bribes, so what? I've seen it with my own two eyes, type of thing. Forget the bribe.
Yes.
But I'm conscious, my lord, I'm preying on your time. I don't know how you want to proceed. I see what the time is now.
Well, obviously you have more time tomorrow. We perhaps, speaking for myself, the point you've made about how you could find out after the event that a juror was corrupt. And the question then is if the other jurors had voted 10-1 to convict, completely ignorant of the fact that would the verdict nevertheless be vitiated, and it would have to. And I think if it were, it would be on the basis that we've been discussing, that there is, as it were, a non-quorate
non-quorate point, really, yeah.
Which suggests it may suggest that the point we made earlier, the point I made earlier about based on. Seraphim may not be quite as obvious where you have 11 judges, as it were, as it is where you've got one judge.
As in that case.
Well, shall we leave it there, Philip?
I'm so sorry. Yes. The case that you mentioned in Strasbourg about the racist members of the jury, do you have the reference?
Mr. Turnbull has the reference. It's Gregory v. UK, page 7914. And I have a feeling there are two other cases which similar issues arose. Yeah. I cannot quite remember. If you give me one set, sorry? Sander's one of them. Is there? And there was another one too.
There's a Russian case, which is not exactly on point, Tinkov.
Oh yes, there's the Russian case, that's right, yes. Yep. 8373. At 37, 8373, thank you.
Very well.
Sander?
Sorry,
7960.
Thank you.
Well, I think we may have reached a convenient point to adjourn for the day. We'll consider where we are in relation to the JS2 point ourselves, and we'll look forward to hearing the remainder of your submissions tomorrow, Mr. Knox.
I will.